If your landlord ever changes the locks while you are out, shuts off your heat in the middle of winter, or tells you to be gone by Friday, stop. None of that is legal, not in any province in Canada. And here is the part that catches most people off guard. It does not matter what your lease says. You can sign a piece of paper agreeing to almost anything, but if a clause breaks the law, that clause is worthless. Today, I am going to walk you through the clearest signs your landlord is crossing the line and exactly what you can do about it. No law degree required. One quick heads up before we start. Renting law in Canada is set by each province, not by the country as a whole, so a few of the exact numbers depend on where you live. But the big rights I am about to cover hold true from coast to coast. Let's get into it. Sign number 1, and it is the most serious. Your landlord changes the locks or physically blocks you from getting into your own home. A lot of people assume that if they are behind on rent, the landlord can simply lock them out. They cannot. Anywhere in Canada, your landlord is never allowed to remove you themselves. They cannot change the locks, and they cannot put your belongings out on the curb. The only way anyone is removed from a rental is through an official order, carried out by a sheriff or a bailiff. Never by the landlord with a screwdriver and a bad attitude. So if you have been locked out, that is not an eviction. That is an illegal lockout, and you can call your provincial tenancy board, and in many cases even the police, to get back inside. Sign number 2. The heat, water, or electricity suddenly goes off, and your landlord is the one who turned it off. This is a tactic some landlords use to make life so uncomfortable that you will leave on your own. It is flatly illegal across the country. Your landlord cannot cut off your essential services to push you out, and it ties into something bigger. In every province, your landlord has a legal duty to keep your home livable. Working heat, running water, and safe wiring are not favors. They are legal obligations. If your services get shut off to force your hand, write down the date and time and report it to your tenancy board right away. Sign number 3 is the one almost everyone lets slide. Your landlord walks in whenever they feel like it. Maybe they just stopped by. Maybe they used their key while you were at work. Here is the rule. In every province, your landlord has to give you advance notice before entering, usually around 24 hours, and in writing, except in a genuine emergency like a burst pipe or a fire. Your home is legally yours to enjoy in private while you live there. So a landlord who lets themselves in for a quick inspection with no notice is breaking the law, and they can actually be ordered to compensate you for it. You do not have to be rude about it. You just have to know that owning the place does not mean they can come and go as they please. Sign number 4. You get a verbal eviction. Your landlord calls, texts, or knocks and says, "I need you out by the end of the month." Take a breath, because a verbal eviction is worth exactly nothing. In every Canadian province, a real eviction has to be in writing. It has to give a valid legal reason, such as serious non-payment or the owner moving in, and it has to go through the provincial board, where you get a hearing to tell your side. No order means no eviction. So if someone is trying to scare you out with a phone call and a deadline, that is not the law talking. That is a landlord hoping you do not know the law. Sign number 5 shows up before you even move in. Discrimination. If a landlord refuses to rent to you or treats you differently because of your race, your religion, a disability, whether you have children, or where you came from, that is illegal everywhere in Canada. These are called protected grounds, and they are backed by human rights law. No families or no newcomers is not a house rule. It is a human rights complaint waiting to happen, and you can file one with your provincial human rights tribunal. Now here is where I have to be straight with you. A few things genuinely depend on where you live, and anyone who gives you one single number for all of Canada is guessing. How much your deposit can be, how much your rent can go up each year, and exactly how much notice you have to give all change from province to province. Alberta, for example, has no cap on rent increases at all, while other provinces set a yearly limit. So do not take a number from a video, not even mine, as the final word. The smartest move you can make is to look up your own provincial tenancy board. I have put a list of every one of them in the description below. Find yours and bookmark it. It is the single most useful thing you can do as a renter, because the day you actually need it, you will already know exactly where to go. So let's recap the warning signs. A lockout, your utilities cut off, a landlord walking in with no notice, a verbal eviction, or being turned away for who you are. If any of these are happening to you, you are not powerless, and you are almost certainly not in the wrong. Write down what happened, with dates, and contact your provincial board. One quick but important note. This is general information for Canada, not legal advice for your specific situation, so always check your local rules before you act. If this cleared things up, the next video breaks down what your landlord can legally keep from your deposit and what they absolutely cannot. Know your rights. No law degree required.